Okay. Good morning, everyone, and good morning to everyone on the platform. I will start to introduce myself. I'm Samantha Brits, Senior Legal Administration Officer from the Department of Justice, Free State, based at the Provincial Office. With me today at the maintenance webinar is Advocate van Rensburg, Ernst van Rensburg, from the SOCA unit of the NPA, based at the DPP's office in the Free State here in Bloemfontein, as well as Julian du Plessis, who is our maintenance officer stationed at Bloemfontein Magistrates Court. Colleagues, you can just also say good morning to everyone.
Morning, everyone. Morning, everyone. I hope you find this session insightful.
All right. So without further ado, let's start with our questions. You can see that I've got a number of questions for the two of you today on this maintenance webinar. Maintenance is obviously a very emotionally charged topic, so I hope that our viewers today will find it very informative. And Ernst, then I will start with you. As I said, it's a very emotional topic, maintenance. So if I want to claim maintenance, how would I know if I am able to claim maintenance from someone?
Samantha, our maintenance law mainly derives from the common law, which is our Roman Dutch law. So all the requirements for a person to be to pay maintenance, you will find in the common law. So I want to make it clear: the duty to maintain is derived from the common law, not from a maintenance order. The maintenance order is the piece of paper that regulates that duty. So even in the absence of a maintenance order, there will still be a duty on someone to pay maintenance if all the other requirements are met. So our common law is the main source for our maintenance law, but it is in South Africa, the maintenance law is regulated by the Maintenance Act, Act 99 of 1998, which mainly prescribes the procedure involved in claiming maintenance. It prescribes the process, the powers of the officials that are involved in the process, and it regulates the issuing of maintenance orders, which will obviously then define that duty to maintain. So for you to be able to claim maintenance from someone, there need to be mainly three requirements present. Firstly, there need to be a certain relationship between yourself and the person that you want to claim maintenance from. And those relationships we derive from the common law. The most prevalent one, the one that we all know, is the duty on parents to maintain their children. So we're talking about affinity in the direct line, parents and children below them, or children and parents above them. So there's a duty on parents to maintain children. Then there will also be a duty on grandparents to maintain grandchildren if there are no parents that can maintain the children. So, and then we can even go further than that. So in the direct line, there's no limit to the relation, to the degree of remoteness between the parties. So great grandparents can be liable to pay maintenance for great grandchildren. But we must keep in mind that that relationship is not only from the top to the bottom, it also goes from the bottom upwards. So there will also be a duty on children to maintain their parents, grandchildren to maintain grandparents, and great-grandchildren to maintain great-grandparents. And that is important to keep in mind if we see these older people, elderlies, that stand in lines at SASSA while their children drive around in Mercedes Benzes. Firstly, there's the direct line affinity. Then there's also a duty on collaterals to maintain each other. That means brothers and sisters. So there will be a duty if there's no father for a child, no grandparents. There may, in certain circumstances, be a duty on the brother or sister to maintain their sibling. That also goes for half brothers and half sisters. So that's your second kind of relationship. And then thirdly, there will be a duty on spouses to maintain each other. Now, I want to just go back to children. Obviously, adoption, in terms of the Children's Act, when you adopt a child, that child assumes the same legal rights as a biological child. So adoption will also give rise to a maintenance duty on the adoptive parents. And we have case law which also there was a judgment that tells us that even a customary law adoption, not one that went through the children's court, but a customary law adoption can also give rise in certain circumstances to a legal duty to maintain. I've talked about spousal maintenance. So if there's a legal marriage, we all know that if a customary marriage needs to be, if you want it to be recognized by our Department of Home Affairs, you need to register that customary marriage. But even in the absence of that registration, if all the customs have been met for a certain culture and there was a marriage concluded in terms of customary law, even in the absence of the registration of that marriage, there may still be a legal duty on those spouses to maintain each other. And also for customary adoptions, as I've said. I just want to also touch on deceased estates. If the person that must maintain another person is deceased, that duty of maintenance goes to the estate. So in those circumstances, the person in need of maintenance will lodge a claim for maintenance at the master's office, and the executor of that estate must ensure that maintenance is paid from the estate. Okay, so we need a certain kind of relationship between the parties. Second most important thing will be there should be a need for maintenance. So you can't just go and claim maintenance because you want extra money or pocket money. There should be a need for maintenance for you to be maintained. So that needs to exist. And then thirdly, there needs to be the ability to pay maintenance. It's no use going to a maintenance court or issuing an order against someone that's not able to pay maintenance and does not have the ability or means financially to pay maintenance. So those are your three main requirements. So if you see those things are present in your set of circumstances, you should be able to succeed with a maintenance claim in a maintenance court.
Thank you, Ernst. I think now that we know when can I claim maintenance, Julian, my next question will be directed to you. So obviously now I have to go somewhere to institute my maintenance claim. So where do I go to do that, and what do I need?
Thank you, Samantha. Thank you for the platform. All your magistrates court in South Africa is a maintenance court as well. So you can go to your nearest maintenance court in the jurisdiction where you are residing or where you are working. So if the child is residing with you or with your aunt or with a grandmother, whoever the person is residing with the child can go to the nearest magistrate court and file for an application for maintenance. You need to take the specific documents with you, which is normally your certified ID copy, the children's birth certificates. All maintenance courts lately requires that you also submit your bank statements in addition where a maintenance order is granted. Then the court can already start making those payments into the bank accounts or from the employer. So your nearest maintenance court will be your magistrate court in the jurisdiction where you are residing, and those are the documents you need to take with you. Thank you so much, Samantha.
Thank you, Julian. So at least we know now that it's information that is in your possession. It's not something that we have to find somewhere else or apply for. So it is documents that a client or maintenance beneficiary will have in their possession.
You should have it readily available. It should be in your possession. You can go to your nearest court for assistance.
All right, thank you for that. Now, I'm going to go this step by step from entitlement to claim, and then where do I go and what I need. So, Ernst, my next question will then be directed at you. When I come to the magistrate's court, it's quite an intimidating environment. So, who will I meet at the maintenance court? What will I find there? Who will be there? Who will assist me?
I'll get to that just now. This is one thing I want to add to what Julian has said about the jurisdiction of maintenance courts. Keep in mind that physical proximity of the child that you care for is not a requirement. So if you have a situation where the child that you are claiming maintenance for stays with a grandmother in a different court's jurisdiction, but you are the one financially supporting the child, so you basically send money to the grandmother to buy necessities for the child, then you should still be able to claim maintenance in your court jurisdiction. You don't have to go to that court where the child resides if he or she stays with a grandmother. I just wanted to make that clear. All right, so you go to the maintenance court. What can you expect? Who will be there? the first person that you will see will be the clerk of the maintenance court, the administrative official, if I can put a label on the clerk. So that will be the person that will assist you, that will assist you to complete the application form for maintenance. There is a certain form, and that form also requires you to state the expenses that you incur for the child. It contains your personal particulars. It contains the personal particulars of the person that you are claiming maintenance from, or the respondent. So you will first meet the maintenance clerk, who does all those administrative duties. You are entitled to have an attorney represent you to go through this process. It's your choice to have an attorney or not. You must keep in mind attorneys will ask fees, and they will ask you for money to help you with this claim. So it's your choice whether you want to do that, but there are officials at the court to assist you through the process, and it's not a complicated process. The forms are not very difficult to complete, and you will get assistance at the court to help you with this. So you will meet a maintenance clerk. There's also at the court, you will find maintenance officers. Now, every prosecutor at a court is also deemed to be a maintenance officer. Those are your legal officials that will assist you with the maintenance inquiry itself. That is the process where the court determines whether there should be a maintenance order and what the amount of that order should be. So the maintenance officer is the official that will facilitate that process, and we will assist you. Keep in mind, the officer is not your representative. He or she is not a representative of any of the parties for that matter, but that official is there for the benefit of the court, to put all the relevant facts before court and to assist the court in reaching a conclusion around the maintenance claim that was lodged. So you will get your maintenance officers, then you will get maintenance investigators at the court. These are the policemen and policewomen of the maintenance system. They are the ones doing the inquiries, and I think Julian, in one of his later, he will explain to us a bit later what the duties and the functions of maintenance investigators are. And then you will also find magistrates or presiding officers at a maintenance court. Those are the people that will eventually decide your fate. Those are the people that will listen to all the evidence or listen to the presentations by the parties, and then will make a call, will make a judgment or a ruling as to whether there should be a maintenance order and what the quantum or amount involved will be for that maintenance order. And as I've said, you can have an attorney to represent you. Also, the respondent may have an attorney to represent you, but the maintenance officer will always play an active role throughout this process and will guide the parties towards reaching a settlement or getting the case to get to a conclusion. So that is what you will find at the court.
Good. Aaron, don't put down the mic. There's still another question that I have for you. You touched a little bit on the forms that need to be completed at the clerk. So as I alluded to earlier, when you get to the maintenance court, especially if you're a first-time beneficiary claiming for maintenance, it can be quite intimidating. It can be confusing. You don't know where to go and what to do. So maybe just explain a little bit more on what happens after I've now filed my application for maintenance. What can we expect then after that?
All right. You'll recall that I've told you about the maintenance clerk, who will be the first person you see, and the clerk will assist you with the completion of the application form, the complaint form. So the clerk will open a court file for you, and they will register that file by allocating a reference number to that file, a registration number, so that your file can be identified later on. And the clerk will ensure that all the documents that you've submitted in support of your application will get onto the maintenance file. Most courts, the Department of Justice is slowly going over to an electronic system, but most offices, in fact, I think all of them still, are using the paper system to keep maintenance files, and they sometimes get lost in the system. That's unfortunate, the truth. So what I suggest, if you do go to a maintenance court, keep copies of your application and the documents in support of your application, so that in case you may need it later on, that you have copies available. So a file will be opened. As soon as the file is opened, the file will be referred to a maintenance officer, because the Maintenance Act requires that all maintenance complaints must be investigated by a maintenance officer before the officer will make a judgment whether the application should be enrolled or not. Now, this entails that the maintenance officer must establish whether the court has jurisdiction, whether there's a need for maintenance at this stage, whether those three legs that I mentioned earlier are prevalent in this application. The officer will also need to determine whether there's any outstanding information on the file, and then the officer must try to get this information before enrolling the application for a maintenance inquiry. The most effective way for the maintenance officer to get the relevant information is to call the parties to his or her office, to get the information directly from them. But and there is a process available for that. But the officer can also make use of other measures, like getting bank statements from courts through subpoenaing those banks, and using the investigator and instructing the investigator to get information that we will get to a bit later on. So once the investigation has been done by the maintenance officer, then the maintenance officer must make a judgment whether there is in fact grounds for the complaint to be put on the court roll. And if there are, the maintenance officer will determine a court date and enroll that matter, and call the parties or subpoena the parties to court for the maintenance inquiry itself. So you'll get as they call it, the court date, and you will get a notice from court to come to court on that date, and then the process for the inquiry will evolve from there.
Okay, thank you. So it's safe to say that our maintenance beneficiaries should work hand in glove with our maintenance officers to ensure that they provide as much information as possible, also to speed up the process. But now, Julian, earlier Ernst has mentioned that you will explain to us what maintenance investigators and officers do. So let's say I get to court, but I'm not sure what the whereabouts is of the person from whom I'm claiming maintenance, or what his financial position is. Is there any way that the court can help me? Can they still help me?
By all means necessary. Thank you, Samantha. We all find ourselves in a predicament where you might not have all the information about the respondent. You might not know where he works, where he stays. So any information is important. If you have a date of birth, if you have a cell phone number, it will be of assistance. You bring that information to court. We lodge our investigations in terms of Section 6, Regulation 3, where we get the information. We will do an ITC check on the respondent on if his cell phone number is on the RICA system. We will be able to check where he's working. We will check where he's residing. So that is already an assistance to us. Our investigators can also go to the extent of getting all financial documents in terms of Section 8 of the Maintenance Act, which all banks will be subpoenaed to provide such information with regards to the financial position of such respondents. They can also go to financial institutions like your pension funds, your provident funds. So all those information is quite important for us to start a maintenance inquiry first, because it will all depend on the affordability of the respondent. So if you have any information regarding the residence or the work address of the respondent, it will be of utmost importance. Thank you, Samantha.
Thank you, Julian. Then, Ernst, I want to say that there's another burning question, I'm sure, to a lot of our participants on the platform, is when I go to court and I claim maintenance, how does the court in actual fact determine the amount that I am able to claim, or that must be paid towards me as a beneficiary?
All right. We've dealt with the officers investigated the complaint, obtained the relevant information. So now the D-Day has arrived. Your court date is here. So you go to court. Normally both parties will then be present at the court. The first person that you will see at the court will be the maintenance officer, who will facilitate the maintenance inquiry process. Now, normally there is a negotiation process underway, and that gets facilitated by the maintenance officer, because it's not necessary that all maintenance matters go to a formal court setup where evidence is presented, cross-examination takes place, and so forth. If the parties want to settle the matter, and normally we get the parties into an office, have negotiations between them to see whether we cannot come to some kind of amicable agreement as to the amount of maintenance that should be paid. But in the same breath, I want to emphasize that the maintenance officer has a duty to ensure that there's still adequate maintenance. So it's not a situation where the maintenance officer will look at the complainant's application. Oh, you're claiming 3,000 Rand a month. Respondent offers 1,000, split it down the middle. Let's say it was 2,000 Rand a month maintenance. That's not the way it works. There is a set way in which the amount of maintenance should be determined. And the obvious place to start will be to do a needs assessment for the, I'm going to talk about child maintenance now because that makes up 95% of the cases on the court roll. But remember, this is applicable to all other maintenance duties, spousal maintenance, whatever the case may be. So you first do a needs assessment for the child or the children involved, and that normally gets done through a list of expenses for the children that the custodian parent, and I'm going to say the mother because that's also in 90% of the cases, the case where the mother will be the custodian parent, where where she submits a list of the expenses for the children. That's why I again say the maintenance officer is not the representative of the mother or the complainant. So the maintenance officer can be critical towards some of the expenses because we find that some applicants inflate maintenance claims and inflate expenses to support their inflated claim. So look critically at the list of expenses provided for the children to do the needs assessment. The officer can also get inputs from the father, which of these expenses is in dispute, which of these expenses he does not agree with. And in this process, the living standard of the parties will play a role because you will get, it depends whether they are rich people, whether they are normal people, whether they live in squatter camps. So the living standard will play a role as to what kind of expenses we're having music in the background, what kind of expenses we can take into account when we're doing the needs assessment. Eventually, the idea is that you determine a monthly amount of maintenance for the child or the children involved. Once you've done the needs assessment, there is a duty on both parents to maintain the children in ratio to their ability or their means. So it's not just the father's duty or the mother's duty to ensure that the children gets fed and that their needs get attended to. So if it is a situation where the father and the mother both are working and they both earn more or less the same income, we will end up with a 50-50 contribution from each. So that needs assessment that was done, you can safely say that the father should make a contribution of half of that, of the expenses. But it may be that the father earns more and has the ability to contribute more towards the needs of the child, and then that father's contribution should be more than what the mother's contribution should be. An example, if the father earns 20,000 Rand a month, the mother 10,000 Rand a month, combined income is 30,000 Rand a month, father's portion of that income is 2/3 or 66%, and that gives you an indication that he should contribute around 66% towards the needs. Keep in mind the expenses that for the child, it's not only child-specific expenses like school fees, the food for the child. It also includes a roof over the child's head, rental or bond payments, electricity payments, water, all those kind of communal expenses for a household. You will also apportion a certain portion to the child. The maintenance officers have received training and they know how to do that calculation, and we don't have time to really go into all of that just now. But keep in mind, you are entitled to include those expenses when you draft a needs list for the child as the complainant. So as I've said, once you've determined the need, look at the contribution that each parent must make, and then you can look at if the father now comes and say, no, I cannot afford what you say, I must contribute, you can look at what the father's expenses are. And then we have case law, and it's tried law that certain expenses and even debts cannot have preference over a father's maintenance obligation. So if he comes and he says, I must pay my credit card, therefore I cannot pay adequate maintenance, that's not a valid excuse. He should make arrangements then with the bank for other payments for his credit cards. So that will give you an indication how the amount is determined. So if if the parties can come to an agreement, that agreement gets entered onto an official court document, which the court will make an order of court, which eventually becomes your court order. If the parties cannot agree to an amount of maintenance, the matter gets referred to a formal court setup where the parties will appear in court. The complainant will get the opportunity to state her case under oath in the witness box, like you see on TV where trials are, and the mother will testify. These are the needs of the children. She will be cross-examined by the father or his attorney, and then once she's put all the facts before court with the assistance of the maintenance officer, then it's the respondent's turn. He will tell the court why he says he cannot pay what is required and list these expenses, and then the magistrate will make a call as to how much the maintenance order should be. And that's the end. Then both parties need to abide by that. The order is appealable, so if the party is not satisfied with the magistrate's decision, they can lodge an appeal at the High Court from the maintenance court. And that's in short what you can expect at court.
Thank you so much. So 3 important things that I've taken from your response is it's not always what we want to claim, but rather the needs of the child or the person that we are claiming for, the financial ability of the 2 parties, and then obviously the child gets preference above everything else. So thank you for that. So Julian, as I said earlier, maintenance is quite an emotionally charged topic, and we know that once we are at maintenance court, the emotion runs very high, and you need to deal with that. So in a situation where a father, for example, disputes paternity, is there a process in place, or can the court assist us to determine paternity?
Yes, thank you, Samantha. Normally on your first appearance, the alleged father will say, listen, I'm not sure this is my child. I want to be sure. I want a DNA test. Then you will be in a position to arrange a DNA test. The maintenance court are not to per se a court where DNA tests are being done, but we arrange at the nearest pathologist or the nearest hospital, normally at the cost of both the parties. So the court can also make an order as for the state to assist with a DNA purchase order in a situation where the court already had made an inquiry into the finances of the parties and to establish whether are they in a position to pay for the DNA test or not. In circumstances where they financially are in a position to pay for the DNA test, in terms of Section 21, the court may then direct them to the nearest pathologist or to the hospital for such a DNA test. DNA test can be done through a blood sample, a hair sample, a nail sample, or a swab from the mouth. So people where you are not sure whether a child is not yours, it is not to say you are now saying to the mother of the child there was infidelity. You just want to be sure, and it is in his rights to ask for a DNA test. So you do your paternity test. You will wait about 3 to 4 weeks for the results to be made available. And once those results are available, you'll know at least by 99.9% whether the alleged father is the father or not. And the court may make such an order for the state to pay for the DNA test. So the court can pay for such DNA test if the parties are not financially able to pay for such DNA test. Thank you, Samantha.
Thank you, Julian. I think that is some good news for the alleged fathers to know that there is a process that also protects them in some way. So then, Ernst, I want to ask you a question. Sometimes we hear that maintenance beneficiaries, and in some instances the mothers, they don't want to go to court and claim maintenance due to the fact that it sometimes takes very long for these matters to finalize. They get postponed repeatedly. So is there a way that the maintenance court can assist in finalizing or speeding up the process of a maintenance matter?
Yes, unfortunately, you get situations where a maintenance matter is dragging on for months and months before getting finalized, and there are various reasons for that. It depends. It can be due to unavailability of court officials or magistrates. It can be due to one party frustrating the process. But be that as it may, there can be various causes for a maintenance matter to be delayed in finalization. But we must keep in mind that even the Act itself prescribes and puts an obligation on our maintenance courts to conclude maintenance inquiries speedily and limit postponement. So there's actually a statutory obligation on courts to ensure that matters don't get postponed unnecessarily. Um, so you should object if there is an application for a postponement for a maintenance inquiry if you appear in a maintenance court and you feel there's not a valid ground for that application. There's also a provision in the Maintenance Act which makes it possible for the court, if a postponement is granted for whatever reason, that the court may issue an interim maintenance order pending the postponement and the finalization of the inquiry. So, and the interim order has the same effect than a final order. There must be compliance with that interim order. So in that, you will then, as the complainant, in the meantime, pending the finalization of the inquiry, receive maintenance in terms of the interim order. And obviously then once the inquiry is finalized, the court can confirm the interim order or make a different order if eventually it is shown that another order is more relevant or more suitable for the circumstances. But even in addition to the statutory provisions that we have available, we must keep in mind first maintenance order. So if you apply to court the first time for a first maintenance order, the Maintenance Act provides that first maintenance orders can make provision for maintenance that should have been paid by the father from the date of the child's birth until the date of the inquiry. So the order, that first order can make provision for maintenance that should have been paid up until the date that you get your order. And that should also address that time delay. And if you have an application for an increase, for instance, in substitution of an existing order, and that application is delayed for some reason, we have common law and case law which says that substitution orders can be made with retrospective effect or backdated. So a court can today make an increased maintenance order but backdate the effect of that order until the date that you lodged your application. And then obviously that increased maintenance that should have been paid from the date of the application until the date of the order can be provided for in the order. So there are ways and means that we can address delays in maintenance matter that you should not suffer or be prejudiced because of the delay. Yes, thank you.
Thank you, Arends. So let's say fine, I've now established that I can claim maintenance and I go to the maintenance court, I fill in the documents and the maintenance officer presents the case and all of the other administration is now complete and we are in court. So can a maintenance order only make, maintenance court, my apologies, only make one type of order or are there different orders that can be granted in such an application?
We have one main statutory provision that authorizes a court to make maintenance order, and that provision gives the maintenance court far-reaching powers what kind of things to include in a maintenance order. Keep in mind that there's also a definition of a maintenance order in the Maintenance Act, and that definition requires that an amount of money must be payable. So you will not get a maintenance order that provides for the provision of cows or a house or a car. You will rather get a maintenance order that is certain, and normally it's a monthly amount of money that must be paid for maintenance. So you have your normal maintenance order that will provide for a monthly amount of maintenance. The Act also makes provision that a maintenance court can order a respondent to register a dependent on his medical aid. So the child must be then put on the medical aid of the respondent, or that he must pay the medical expenses for that child. There's also a provision where a mother that had expenses when she was pregnant with a child and expenses related to the birth, the lying-in expenses as we call it, those expenses can also be included in a first maintenance order where the father can be ordered to make a contribution towards the lying-in expenses of the child. And as I've said at the previous question, all maintenance that he should have paid up from the date of the child's birth until the date of the issuing of the order can be included in that first maintenance order. There's even a provision that the father can be ordered, and I want to differentiate now between garnishee orders here and stop orders. Remember, stop order is where you go to the bank and you on your own go and arrange that money be deducted from your bank account for a certain payment. But the father can be ordered in the order itself to go and make arrangements for a stop order on his bank account, so that the maintenance can be paid via stop order. It's just a bit of a measure to ensure that maintenance is paid. On top of that, there is a provision in the Act which allows for consent maintenance order. This is a situation where the father normally stays outside the court's jurisdiction in a different town or city. He's prepared to make an offer for maintenance. He makes that offer on a certain form, and if the mother or the complainant is prepared to accept that offer, the court can make the order without the father having to come to court for that order to be issued. So it's made by consent. The father does not have to be present on the day of the inquiry, and the court then on that day just issues the order based on the consent by both the offer made by the father and the acceptance of that offer by the applicant. And then lastly, you get what they call default maintenance orders. This is a situation where the father received notice to come to court with a subpoena, but he has knowledge of the court date. He's absent at court on that date. The court is satisfied that he has knowledge and he received notice of the court date, and he has knowledge that he should be at court, or that the case was previously postponed and he was warned to come to court on that date. He's absent, then the court can proceed to make an order in his absence. So the court will consider the needs of the child, whatever information may be available about the father's ability to pay, and if the court finds that he or she has enough evidence, enough facts available to make such an order, the court then makes a default order in the father's absence, which is then enforceable against him.
Thank you. This is quite interesting, I have to say. So Julian, we've heard about the different types of orders, and I must say it's quite interesting to know what the court can do. You think it's only a once-off payment of maintenance, and there you go. But tell me, I'm sure that there's someone also on the platform that want to know about garnishee orders. Can the court grant a garnishee order against the person's employer, against whom I'm claiming maintenance? Is that possible, and how does it work?
Indeed, Samantha, it is possible. You will normally lodge your application for arrear maintenance in terms of Section 26 of the Maintenance Act. This is when someone now fall behind with their monthly maintenance payments, and then you'll bring your bank statements that will prove that the respondent failed to make the payments in terms of the maintenance order. You'll then either apply for an emoluments attachment order, like you mentioned now, the garnish order, or you can apply even for a warrant of execution to be executed against whatever movable property the respondent has in a situation where he does not receive a monthly salary from an employer. So your applicant will bring a bank statement. You will file an affidavit with the nearest court to say, I've got the maintenance order. The respondent has not been complying with the maintenance order. I'm applying that it be deducted as an emoluments attachment order from his salary. The court then grant a provisional order where it is being sent to both the employer as well as the respondent who was defaulting, to give them an opportunity on a return day to come and explain and give reasons why that order should not be made a final order. If it is served properly on both the respondent as well as the employer, and there's proper service on the date of the return, the court will grant a final order for the money to be deducted as a garnish order from the salary every month. In your situations where the respondents are self-employed or they are farmers, they've got other means of income without a monthly salary, the court may also grant a warrant of execution in terms of Section 27 of the Maintenance Act, where if there's any movable property like a car, any furniture that can be taken by the sheriff, it will go on an auction. The auction will be dealt with in relation with the Sheriff's Act There will be a 21-day notice in the government gazette where someone that has any intentions to oppose it may also file their notices. But in your normal circumstances where someone is working for your a monthly salary, you can ask for an emoluments attachment order.
Thank you. Yes, please.
Thanks. Julian, I just want to add to that, and for the benefit of the viewers as well. Julian is correct. You are talking about addressing arrear maintenance through the section, that process that you've explained. But we must keep in mind that our Maintenance Act also makes provision for, in the layman's terms, garnishee orders, which is not an emoluments attachment order. It's an order against a third party to deduct. No, I'm not talking about arrear maintenance now. I'm talking about your normal monthly maintenance, to deduct the normal monthly maintenance from the salary of the respondent. And I want to emphasize that this has nothing to do with your credit record. This does not reflect on your credit record. It is just a measure to ensure that maintenance are paid. And there's a third party that is held responsible to jointly with the respondent ensure that maintenance is paid every month. The process that Julian explained now is more relevant for arrear maintenance and an emoluments attachment order where an additional amount is deducted from your salary to recover arrears will obviously have an influence on your credit records.
Thank you, Aaron. So in essence, it's almost like a debit order.
Yes. If I can add to that, thank you, Samantha. And I'm thankful for Advocate van Rensburg to highlight it. In terms of section 16(2) of the Maintenance Act, on your first appearance, on your first maintenance order, you can already ask that it be deducted as a garnish order. Rightfully, as Advocate said, it is not influencing your credit record. Only once you fall behind with your maintenance, that will influence your credit record. But it has no influence on your credit record. If you willfully say, I want this money to be deducted from my salary, I don't want to make monthly payments, it will not affect your credit record.
Thank you, Julian. That's very important, and I'm sure that there was quite a number of viewers that was wondering about that aspect. But now, as parents, we look at our children, and on some days we wish that they will just grow up, but on most days we wish that they wouldn't. But the reality is that they do. They grow up, and with inflation, life and maintenance itself gets more expensive. So if I have an existing maintenance order, is there something that I can do? Can I ask for a new maintenance order for a higher amount, to cover the daily cost, as I said, with inflation and everything that gets expensive? Is there something that we can do?
Samantha, you can also approach your nearest court and apply for either an increase of maintenance or in a situation where you can no longer afford to pay the maintenance. Say, for instance, your financial position has deteriorated to such a nature that your maintenance order says you're supposed to pay 2,000 rand a month, you're supposed to keep the child on your medical aid, you're supposed to buy clothing for the child, but you got now a demotion at your work. You are now demoted from a director to a clerk, say, for instance. You no longer get the same salary. It is also duty bound for you to approach the nearest court and say, I can no longer afford to pay the maintenance. In most situations, you will then approach the court, you will bring your proof to show this is what I used to receive. I can no longer pay my maintenance because I'm now receiving this amount of money. In the circumstances where your children grows older, school fees goes up, bread goes up, petrol goes up, you can also approach the court to ask for an increase of that maintenance order. Also remember, if you have an existing divorce court order and it's from a higher court, you can also approach your maintenance court because your maintenance court is what we call a specialized sui generis court that can also amend high court orders. So please don't go to the high court. It will cost you a lot of money. Come to the nearest maintenance court for an application to substitute the current existing order, whether it's for a decrease or an increase of maintenance.
Yes, thank you, Julian. That's very important, especially if you speak about maintenance obligations in terms of a divorce order, that we don't have to approach the High Court again. But Ernst, when I say children grow up and we don't want them to grow up, they do. So I know that children are regarded, or when you turn the age of 18, you are now regarded as an adult. But until what age must maintenance be paid for a child?
I, you can think for yourself. I know of very few children that will be able to support themselves when they turn 18. Most of them are still at school when they turn 18. Our maintenance law does not have a cut-off age um, until when maintenance is payable for the child. The general rule is that maintenance is payable for children until they become self-supporting. It is so that 18 years is the age of majority in terms of our country's laws, where a child becomes an adult in the eyes of the law. Um, but that does not mean that the maintenance obligation will just fall away or will just end there when the child is 18. So, what effect does this have if you are getting maintenance for your child? If there is an existing order in place and the order does not mention until when it will be in force. So you get some divorce orders which will state that maintenance for a child is payable until the child reaches the age of 18 years or reaches the age of majority. Those orders will lapse as soon as the child reaches that age. But keep in mind what I've said earlier. Your maintenance duty is not dependent on the existence of the order. It's a common law duty. So even though that order may lapse because of that specific provision in the order, it does not mean that your duty to maintain falls away. So either the mother or the child may approach the court again for a maintenance order if the child is still in need of maintenance. If the maintenance order that you have currently does not stipulate that it will fall away at a certain age or a certain event, then that order will still be enforceable and valid even after the child turned 18 years of age. So that order will continue as if 18 does not really have any effect until the child becomes self-supporting. Um, Obviously, a child is an adult in the eyes of the law after 18, so the child can also approach the court, him or herself, to claim maintenance against both parents or the parent that's recalcitrant, not paying money. Um, but we also have case law which stipulates that even after a child turned 18 and that child is still dependent on his or her parents, the custodian parent can also still approach the maintenance court for maintenance processes, with a maintenance application on behalf of that child, even after the age of 18 years. Um, so it's not to say that the child now is the only one that can approach the court. If a child still needs maintenance, he's staying with the mother at that stage of his or her life. Um, so keep in mind, 18 is not the magical age to get off if you're paying maintenance.
Definitely. If you think of if your birthday is in January and you turn 18 in January, it does not mean that the responsible parent must now stop maintaining, or either parent must stop maintaining you because you are 18.
Yeah.
So it's
I just want to add there, remember, that doesn't mean for children, if there are young people watching, that you can sit back and don't have to go and look for work. The court will get less tolerant, and the courts, the court will allow lesser expenses and lesser amounts if you are still dependent, but you're not doing an effort from your side to go and find employment or to earn an income, or at least trying to further your studies or your experience and ability. So keep that in mind as a child as well.
Okay, so definitely the court will take the circumstances into consideration when you apply. So Gillian, earlier when Adams were talking about when can I claim maintenance, or when do I qualify, if you will, and then the term popped up, spousal maintenance. So tell me, is it possible to claim for spousal maintenance after a divorce matter is finalized?
Unfortunately not. After the divorce is finalized, one cannot claim spousal maintenance. So it's either for the divorce court to grant the divorce, to grant an order for spousal maintenance, either whether it's rehabilitative maintenance or until death or cohabitation or remarriage. But once the divorce is finalized, one cannot claim spousal maintenance. In the process of divorce, and a spouse feel like they are not being maintained financially like they used to be maintained in during the marriage, they may approach the maintenance court for an interim order with regards to maintenance pending the finalization of the divorce. But once a summons has been issued in either the regional court or the high court, pending the divorce matter, a spouse may not approach the maintenance court. I hope that answers the question, because we get many spouses that approach the maintenance court and say they are being financially burdened with the fact that they must pay attorneys for the divorce matter, and they are not getting any financial assistance from their spouses during the divorce. So you are at liberty to approach the maintenance court for an interim assistance. But once the divorce is finalized, the maintenance court cannot make an order for spousal maintenance.
Thank you. So Aaron's, my next question, it feels like it is a question that a prosecutor must respond to. Let's say there's now a court order and paternity has been proven. In some instances, some fathers or then the respondent still refuses to pay maintenance. Is there any remedies available to the beneficiary that they can follow, and how does that work?
Yes, unfortunately, you get fathers who just does not want to pay, and this is the emotional part of maintenance that we talked about earlier. I always stress when we do training for maintenance, for prosecutors, maintenance officers, and I always tell them, if the father earns a salary or earns a regular source of income from a third party, always make sure that once you issue a maintenance order, before arrears accumulate, please ensure that there's also a garnishee order, the one that doesn't reflect on your credit record. Ensure that there's something like that in place to ensure that there's at least a third party that's also held responsible to ensure that maintenance payments are made. Because once you have a garnishee order against an employer, if the employer fails to make that deduction from the salary, the employer firstly commits an offence in terms of the Maintenance Act, and you can attach the employer's assets for the money that employer failed to deduct on behalf of the employee. So we have measures then against the employer to at least ensure that at the moment that the salary that maintenance is taken off before he gets his money. Be that as it may, you get situations, and I think Julian alluded to it a bit earlier, where you get situations where you cannot have a garnishee order in place, and we're talking about self-employed individuals here, people who have their own businesses, taxi drivers, vendors, those kind of people. So if an employer is involved, you have your garnishee order, there shouldn't be arrears. But those kind of people, there are ways then that we can enforce the order against them. Julian alluded to a civil process of enforcement. That means as soon as there's arrears, the complainant can approach the maintenance court and apply for the enforcement of the order by means of civil measures. Now, the Maintenance Act provides for 3 different kinds of civil enforcement measures. Firstly, as Julian has said, you have your attachment of assets or the warrant of execution. That's where the respondent has a car, he's got a television, he's got furniture, whatever the case may be, some movable property, and he may have immovable property like a house, whatever the case may be. So we can apply for that to be attached by the sheriff of the court and then sold in execution, and then the proceeds of that sale will go towards the arrear maintenance. Secondly, you have a civil enforcement measure, which is your emoluments attachment order. And hopefully, if you've done your garnishee order, there shouldn't be something like this. But if you haven't, emoluments attachment order, and there's also an order against the employer to deduct additional money from the salary to recover arrear maintenance on top of your normal monthly maintenance. And then thirdly, you have an enforcement measure civilly called attachment of debt. That is a situation where you obtain orders in the maintenance court against third parties who owe money to the respondent, but you order them not to pay him the money, but to pay the money towards arrear maintenance to the complainant. So those are your 3 civil enforcement measures. But on top of that, failure to comply with the maintenance order is also an offence in terms of the Maintenance Act. So you commit an offence like any other crime, commit a crime. And then if the prosecutor can prove all the elements of the offence, the court will convict you if you get prosecuted. And once convicted, the court, you can get up to 3 years imprisonment for failure to comply with the maintenance order. The court can also issue compensation orders against you, and the court may even, or the court can issue a suspended sentence against you on condition that you pay the maintenance at certain terms or repay the arrears on certain terms. I want to stress here as well that the failure to comply with the order does not only refer to arrear maintenance. You get situations where the payment every month must be made by a certain date. But just to frustrate it or just to be spiteful, some maintenance payers pay late or they pay whenever they will. They're still in contempt of that court order because they must pay by a certain date. Or this order also stipulates where that maintenance must be paid, into which bank account or to which institution. So if he chooses to give the money to the child, he's also in contempt of the court. So you can also prosecute him. So even if there's not arrears, if there are other conditions in the order that's not met, you can also do a prosecution in terms of Section 31 of the Maintenance Act. I just want to also quickly make you aware that there are other offences that the Maintenance Act also creates, which may be, there are various, but the most important ones for the viewers' purposes, I think, false information. If you provide false information during a maintenance inquiry, you commit an offence and you can be prosecuted. If you refuse to provide relevant information for the purposes of a maintenance inquiry, you can be prosecuted. If you disrupt the proceedings at the maintenance inquiry, you can be prosecuted. If you obstruct a maintenance investigator in the performance of the investigator's duty, you commit an offence and you can be prosecuted. And very important for the maintenance payers, there's a duty on you to inform the court if you change your place of residence, your address, or your place or your place of employment, the new address. So if that change within 7 days of you changing that address, you must inform the court in writing of the new address. If you do not do that, you also commit an offence and you can be prosecuted and punished for not doing that. So please be aware of that requirement. But that's the way in which the Maintenance Act provides you, the measures that the Maintenance Act provide for the enforcement of orders. We must keep in mind that the High Court is still there, so there can be contempt of court proceedings in the High Court if you want to pay an attorney to assist you to do that. That's also available as an option. But yes, thank you.
Thank you. So, Arends, thank you for that. So, respondents, I think it's very important to take note of this information. And it's best to follow the court order to the T and not be creative and take your own initiative. But Julian, let's talk a little bit about future maintenance. You mentioned earlier that if you can't pay maintenance, if you were demoted or whatever the case might be. But what happens in the instance where a person that's paying maintenance, for example, retires or resigns from his employment? Obviously, this will now affect his ability to pay maintenance. Can the maintenance court assist me with this if I encounter such a situation?
Yes, Samantha. Remember, when someone now retires, the duty to maintain does not automatically fall away. In circumstances where you work your whole life, you work for a certain government department or private department, you build a pension fund or provident fund over the years. Meaning, the duty to support does not automatically fall away. A certain portion of a lump sum should be earmarked for what we call as future maintenance. So the applicant may approach the maintenance court and say, listen, I've received my maintenance order through a garnish order every month, but for the past 3 months, I have not received it. So I suspect the respondent is no longer working. What we do is we then refer the file to the maintenance investigators. They will find out from the employer whether that person is still on the payroll. We get information that he's about to receive his pension money. What we court can do is we can grant an order to interdict any payments for a certain portion of money that we've calculated prior to what should be future maintenance for the minor child. We then work out on what the monthly maintenance order was. Say, for instance, the monthly maintenance was 1,000 Rand. We work out what it would be for over a 12-month period and the years that is left for the child to reach 18 or become self-sufficient. Then we earmark this money. If we then subpoena both parties, we send the interdict to the pension funds to interdict them not to pay out a certain amount with a return date. the respondent is subpoenaed to come and give reasons why that order should not be made final. In most circumstances, we negotiate and we settle on future maintenance. A lump sum is then paid over to what we call the Guardians Fund at the Master of the High Court, and they administer the funds of minor children until they reach the age of 18. Hence, it is very important to know that, and I think I emphasized it earlier, that you still have the means by way of a retirement fund or provident fund. It does not mean your duty to support just falls away. Hence, there is a remedy for future maintenance, and there is the Guardians Fund. Remember, the money also remains the money of the respondent. So, in any circumstances where either the child, say, God forbid, pass away prior to the child reaches the age of 18, the money will still go to the respondent. In any circumstances, the mother may also apply that a certain amount of money can also be paid from that lump sum, maybe for school fees or school trips or any sports activities can also be paid from that future maintenance. So if someone does have a pension fund or provident fund, a lump sum may be earmarked for this. So thank you for that question.
Thank you, Julian. Aaron's, my next question will also be directed to you again. You know, in our country, gender-based violence is quite prevalent, and that includes domestic violence. So I heard that financial abuse in a domestic relationship is also a form of domestic violence. Is that correct?
Yes, you're correct in saying so, Samantha. The domestic violence, I want to just get back to gender-based violence. We sometimes forget that economic abuse is also a form of violence. So it comes down to gender-based violence if you neglect someone financially. So in terms of the Domestic Violence Act, it's Act 116 of 1998. The definition of domestic violence includes economic abuse. And then the Act goes further to give a definition of economic abuse. What is economic abuse? And it gives a definition, but it also includes the deprivation of economic or financial resources to someone that is entitled to that under the law. And that's maintenance. Someone who's entitled to maintenance is entitled to financial resources under law. So the non-payment or non-compliance of a maintenance payer to ensure that payment is done is also then a form of domestic violence and economic abuse. So a complainant who is urgently in need of financial assistance, you're out on the streets or whatever the case may be, you urgently need financial assistance. We've heard now, and we've learned that the maintenance court process takes a bit longer. So if you need urgent relief, you can approach the domestic violence court, where you will ask for a protection order, which will then include a provision that will order the respondent to make a payment towards urgent financial relief for the complainant, or emergency monetary relief, as the Act calls it. So keep that in mind. If you do need urgent assistance and the father or the respondent is just not rendering that assistance, that option is also available to you.
Thank you. I think that is very important, especially in the day and age that we live in. And as we also move towards the build-up of our 16 days of activism, I think that is quite an important aspect to consider. So Julian, my next question will be to you. Let's say with the globalization in South Africa and people immigrating to other countries, can I still claim maintenance if a person stays overseas, the person that I'm claiming from, if he stays overseas? Is that still possible, or has that ship sailed?
Thank you, Samantha. It also boils back to whether the duty to support falls away. If someone moves abroad, the duty to support does not fall away. It just means that he's now in another country, the child still stays in South Africa, he still has a duty to support. So in terms of the reciprocal enforcement of the Maintenance Act orders, in terms of Section 80 of 1963, South Africa has treaties with different countries that such orders may be instituted. So if you know your father is now staying in, or the father of your child is now staying in Australia, he's not paying maintenance, there was never a maintenance order in place, you may approach the nearest court for such an order. The court may grant then what we call a provisional order or a final order, bearing that you provide all the necessary information of the respondent in the country abroad. So if you know he works for a certain construction company in Australia, South Africa perhaps has treaties with the state in Australia where the respondent is residing, we may institute such an order in the court where the child, in the jurisdiction where the child or the mother is residing. The mother will then be placed in the witness box. Certain evidence will be under oath of how much the respondent is receiving, the needs of the child, the whereabouts of the respondent, and the court may grant such an order. These orders are being sent then through to the South African embassies. The South African embassies make such an order through to the nearest court in the jurisdiction where the respondent is residing abroad. That is just briefly. South Africa has a list of countries which they have agreements with, but not all countries does have treaties with South Africa for such maintenance.
Thank you, Julian. So it's no help to fly away. That maintenance order will follow you.
It will follow you.
That's good.
Maybe I can just add to that. The other way around is also applicable. If you are a maintenance payer and you're watching this now, and you are staying in South Africa and the child in need of maintenance or the mother stays abroad, you can just as well then receive a call from your local court if you're not paying your maintenance to come to court if she institutes the proceedings in that reciprocating country. So if she stays in Australia, you may end up having to being called to court here in Bloemfontein, where you have to answer why you're not paying your maintenance, and an order can be made against you to pay maintenance for your child in Australia.
Okay, so there's just no way out. All right, before I open to our viewers to also ask questions, there's one last question that I want to ask you, Aaron. So in normal processes, or in our belief, we would want to think that processes will be flawless and that everything will go according to the book. But the reality is it doesn't happen. So where do I go if I want to lodge a complaint, if my maintenance matter is not properly attended to?
Okay, maintenance is mainly divided into two main parts. You've got your administrative part and then your legal part. Administratively, that's your opening of the court files, the documentation, the safekeeping of the file and so forth, the conduct of clerks. So all your Department of Justice staff, your maintenance clerks, the maintenance investigators, and some of the maintenance officers will fall under the supervision of the court manager of a specific court. So on my general rule, administrative issues, if you have an issue administratively, your next step will be to lodge a complaint or to lay a complaint with the court manager of the court applicable. You also have area court managers appointed by the Department of Justice. So if the court manager does not attend to your complaint to your satisfaction, you can go to your area court manager. And then our Department of Justice also have provincial offices in each province. So you can escalate your complaint to the Provincial Department of Justice office or even the National Office of the Department of Justice. When it comes to the legal issues, that's a court process, the way a prosecutor deals with your matter, whether it's a prosecution or a maintenance inquiry or a civil enforcement process. Your person, the supervisor will normally be your senior prosecutor or most senior prosecutor at the court where the case is being heard. So you then lodge your complaint with a senior prosecutor, or as I'm a senior maintenance prosecutor, there's one of us in each of the provinces. You can also send a complaint to the senior maintenance prosecutor who are stationed at the office of the Director of Public Prosecutions in the province. So you can send your complaint then obviously to the Director's office, or even to the National Office of the National Prosecuting Authority to attend to your legal complaint. And then we have various Chapter 9 institutions, the so-called Chapter 9 institutions in terms of our Constitution, which is your Public Protector, Commission on Gender Equality, South African Human Rights Commission, where you can also send complaints to. They are the watchdogs over our government departments to ensure that we comply with the provisions of the law. So you can send a complaint to one of those Chapter 9 institutions as well. But that's in short the recourse that you have if you feel aggrieved by the way your case is being handled.
Thank you so much. I'm not sure if there was any questions from the viewers.
We have a couple of questions, and then Ms. Maninyani is asking, how long should I wait before I review my order?
Arit, how long?
Review, I presume that's where you want to apply for an increase in the maintenance or substitution of the existing order. There is no prescribed time limit or time frame for in terms of the legislation. The criterion that the court uses is whether there is enough grounds, whether the circumstances of the parties have changed to such an extent that a new order is necessitated. So in your normal run-of-the-mill case, if you get a maintenance order today, with inflation, the annual inflation rate, the child growing, getting a year older, normally within a year, 12 months or so, you should be able to prove to a court that you need a bit more than what you are currently getting. But that doesn't mean if you get an order today and next week your child is in a motor vehicle accident, God forbid, but the child now has specific medical needs which increases the needs of that child to a large extent. There's nothing preventing you from approaching the maintenance court to ask for an increase in the order, even a week after the existing order was made. What we do get quite often, we get maintenance payers who are dissatisfied with an order that was made against them. And then within a month, they come back to the court to apply for reduction in the maintenance. Keep in mind that they must show, and the Act requires that good cause must be shown by an applicant that an existing order should be varied or substituted. So you can't come back with the same set of circumstances if a court has made an order against you and ask for a reduction. The maintenance officer, if he or she does his work properly, should not enroll that application. Your recourse will be to appeal the decision that was made by the court to the High Court. You have the appeal process available and not come and apply for reduction.
Okay.
And can the maintenance order be withdrawn if the other party uses the minor replacement?
Julian?
Maintenance order withdrawn. Normally you will lodge a complaint with the maintenance court to say, I'm paying maintenance, but I suspect the maintenance are not being used for the purposes that I'm paying it for. Then you can lodge a complaint to say money is being used recklessly, or you can go even to your nearest social worker for the social worker to call both parties in and to see what the money is being used for.
And what are the implications if one fails to pay the agreed amount?
Yeah, I think we alluded to that earlier. You have your civil remedies where you can lodge an application for a garnish order or an emoluments attachment order. If someone fails to pay the maintenance, you'll have to prove. You'll bring your bank statements where the court order stipulated that where the money was supposed to be paid in, and you lodge it at your nearest maintenance court. An emoluments attachment order will then be granted against the salary of the respondent.
Maybe I could just add there. There were amendments to the Maintenance Act which provides for, if you have a situation where there's a complainant that claims maintenance and the respondent comes and says, but we have an agreement, even a written agreement that a certain amount of maintenance is being paid, should be paid, and I'm complying with this agreement. It's not a court order, it's a contract for that matter. We have the Maintenance Act does allow a maintenance court to even proceed with a maintenance inquiry to investigate whether an alternative order shouldn't be made instead of the agreement that was made between the parties. So the fact that there's an agreement does not absolve you from coming to the maintenance court for a maintenance inquiry.
Thank you. And can a person pursue someone for maintenance living in New Zealand as we stop paying when the child turned 18, but the child is still studying?
Yes, thank you. This was the question that we answered earlier about the Reciprocal Enforcement of Maintenance Orders Act 80 of 1963. And I'm happy that you mentioned New Zealand because New Zealand is one of the countries that South Africa does have treaties with. So even if the child reaches the age of 18, the duty to support does not fall away. The child is not yet self-sufficient, so the child cannot maintain him or herself. So the person may bring such an application for enforcement of such an order.
Thank you. And on spousal maintenance, after being financially dependent on my partner for 10 years, can I apply for maintenance from him despite us not being married?
Yes, Advocate alluded to it earlier. If there was a duty to maintain, whether it's a civil, a communal marriage, whether they were just residing together, you may approach the court and show cause that there was a duty to maintain, whether you were legally married or not. Yes.
Can I just allude to that? We must just differentiate now between customary marriages not registered and living together partners. Our law at this stage, the maintenance courts, there's some conflicting case law on that, and it will depend largely on the situation, the facts of each case. But in general, our law does not recognize at this stage the a maintenance duty on living together partners. We have pockets where the courts have recognized that there should be a duty on one of the partners, maybe for instance to register the other partner on the medical aid, those kind of situations. But in general, there's no authority that we can use to say that living together partners, there's now just a general duty on all of them to maintain. But remember, it is also a court's duty to expand and build and the law as it stands. So if the law is a reflection of our society, of our community, if there is a need in our society that there should be legal, if we get the prevalence, if most people just live together and not legally get married anymore, isn't there a social need then for our law to recognize living together relationships as giving rise to a legal duty under certain circumstances? And the Law Commission, our South African Law Commission, is looking at that to enact legislation that recognizes this possible duty that may exist. So it is being looked at. And I don't want to say that you can just go to any court to claim maintenance if you're a living together partner. But if, for example, you've been living together for 20 years, you've put all your life into that relationship, I would go to a maintenance court, get the court to say, I cannot help you, and take it on appeal to develop our law. But in general, the answer is unfortunately not at this stage.
And then another question, if I'm remarried and then my new husband is contributing to the household income, will his income be taken into account when determining the amount of child maintenance my ex-husband is required to pay for our children?
Remember, your new husband is not the father to the child, so he's got no duty to support their child.
Yeah, just a proviso to that as well. If your new husband is married in community of property with you, his income is also apportioned to you. So in that way, his income may be looked at to determine your available means to support your children. But there's no legal duty on the new husband to support the children, so he cannot be forced to pay any contribution towards your children from a previous relationship.
And then on the issue of spousal maintenance orders, again, will my maintenance order be automatically revoked if I remarry, or do I need to notify the court or my ex-husband about the change in my marital status?
It will now depend on what the initial divorce order say. If the initial divorce order say that maintenance will lapse automatically after cohabitation, remarriage, or death, then it will lapse automatically. There's not even a need for you to go and inform them that you are now married again, but it will lapse automatically.
Okay. And then this member is asking that she's been responsible for for the upbringing of my child since they were 10 years old and haven't kept receipts for their expenses. If now I want to apply for child maintenance, how can I demonstrate the costs I've incurred for my child's care, and what documentation will be required to support my application?
I think it boils back to where Advocate van Rensburg earlier said that you can even claim retrospective maintenance, and that will be in the court's discretion as to how reasonable that is and what expenses you've already occurred for bringing the child to that age already.
Just add to that, Judy. Keep in mind when you go to maintenance court and you give evidence, you are testifying under oath. So obviously, it's going to be good for your case if you can show documents of past expenses if you want to prove your claim. But your evidence under oath is also evidence the court will take into account. So if you testify that this was the amount that I have spent on when a child broke his arm, and this is the amount that I've spent on milk formula, if it's a baby, or whatever the case may be, the court can take that into account, and the evidentiary value of that may be a bit less than when you have documents to support your evidence, but it doesn't mean that you cannot go to court. If you if you have a reasonable explanation for the expenses and there's an indication that you actually incurred those expenses, the court may just as well find in your favor, even in the absence of documentary proof.
Thank you so much. And the last question, how can applicants appeal or dispute decisions made by maintenance officers?
I presume that's now the decision whether to institute an inquiry or not, because you remember I said that once there's an application for maintenance or for a substitution of an existing order, the maintenance officer has a discretion to institute an inquiry. If you don't agree with the maintenance officer's decision, you can make representations. It's a legal question, so you make representations to your director of public prosecutions or to the most senior prosecutor at that court with your reasons why you say the wrong decision was taken, and that the senior official will then obviously review the decision made by the maintenance officer to see whether he or she agrees with that decision or not. If not, they will overrule the decision by the maintenance officer. If they do agree, then obviously you will be informed that your representations are unsuccessful, and you can then go up the hierarchy where you make representations to the DPP office, to the national office, and then ultimately you can approach the High Court for an order that your matter be placed on the roll if you still disagree with all the decisions taken.
That is all from our side.
I think before we close, there's just time for one or two questions, if that is still okay. Either one of you can answer that. I've recently been confronted with a question on whether a maintenance investigator needs to notify the respondent once he starts his investigation. Is there a need for the investigator to inform him that I'm now conducting an investigation?
I can just as well answer. There's no requirement in the Act that you should be notified, that the respondent must be notified. And in many cases, that will defeat the purpose of the investigation, because you get respondents, unfortunately, who hide their assets for maintenance to avoid paying adequate maintenance. They will close accounts, they will move money in bank accounts, they will hide assets under different names, they will create trusts or companies in which they put the assets to claim that they don't have anything personally, it belongs to a company. So as soon as they receive notice or they receive information that there are investigations into their financial affairs, then they do these things, unfortunately. So that will defeat the whole purpose of the investigation in many of the cases. But there's no requirement in the Act that there should be notice given to the respondent that is being investigated.
Okay, thank you for that. And then my last question would be, let's say there's a notice out to a respondent to appear in court and they fail to appear in court. What happens then?
Thank you, Samantha. It also depends on what kind of notice it is. If it is a subpoena that was issued in terms of Section 10 of the Maintenance Act and he fails to appear without good reasons or without providing perhaps a medical certificate to the court may grant an order by default in his absence. The court will then put the applicant in the witness box under oath, establish the needs of the minor child, perhaps also get some information regarding the income of the respondent. And if the court is satisfied that the needs of the child is being reasonable and the respondent is working, the court may grant an order by default in the absence of the respondent.
Thank you, Julian. Well, colleagues, I want to thank you really for today. I think that the information that you shared was quite informative and educational also for our viewers, and even for myself. Every day you learn something new. And it's quite practical on how it was explained. So I think that makes the process more user-friendly for our court users that is a first-time claimant for maintenance. So thank you very much for availing yourself today and sharing your knowledge with every one of us. Thank you so much.
Thank you for having us, Samantha.
Thank you, and thanks everyone for watching. I hope you learned something from this.
Definitely. Thank you so much.